earpieces were gray. Please only use a black approved earpiece. By default, all unused earpieces will be unplugged at the start of the meeting. When you're not using your earpiece, please place it face down on the middle of the sticker for this purpose that you will find it on the table as indicated. Please consult the cards on the table for guidelines to prevent audio feedback incidents. The room layout has been adjusted to increase the distance between microphones and reduce the chance of feedback from an ambient earpiece. These measures are in place so that we can conduct our business without interruption and to protect the health and safety of all participants, including the interpreters. Thank you for your cooperation. For members in the room, please raise your hand if you wish to speak. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best as we can. We appreciate your understanding in this regard. I now want to welcome back our witnesses from the Justice Department that will help us with technical questions on Bill C-273. Matthias Viltort, Senior Counsel, Criminal Law Policy Section, et Madame Isabelle Descharnay, Counsel, Criminal Law Policy Section. Bienvenue à vous. Merci beaucoup. We're now ready to start clause by clause, and I will recognize Mr. Moore.
Thank you, Madam Chair. Just before we start, I want to quickly flag something. I just want to take a minute of our time, but we're experimenting with this new layout, and I'm hoping that, my feedback so far, now we have, committee support individuals that are not at the table when they used to be at the table. When we want to, sometimes we want to talk about something, but we're 3 miles away from each other. If this is a dramatic change from what we are used to. I'd say witnesses are almost twice as far as they were before. So if, as we review this and we get feedback on it, if there's any way to have it somewhere between where we were and where we are, if that would still accomplish the goals we have on audio feedback, I would certainly hope that we're quickly, clerk, that we're quickly providing feedback on this process. Because to me, there may be an upside on the audio, but there's definitely a downside in the experience. And I know sometimes we have a number of individuals that want to watch committee proceedings. Like we've had some meetings where maybe 4 or 5 rows are taken up of individuals that want to watch, and this format certainly limits that as well. So that's just, I know we've only done it a couple times. That's my initial feedback, and I don't know if there's a process to provide that, but that's my 2 cents.
Thank you, Mr. Moore. And it is the second time that we do it at this meeting. It started Monday, and there is a process actually as a member of the liaison committee. They called a meeting yesterday, pretty quickly to get feedback from chairs, and I'm sure they'll do it again because it is a new process. So quite frankly, I appreciate, as the chair of this committee, feedback from members so that when they do that again, because they will, I'll be able to report what members are telling me. And I appreciate that you like all the members to be close together. That's how this committee has functioned since we started 2+ years ago, and that's very nice. Thank you. I will say one thing, though, that I asked today. For those that may not need translation and, know English and French, if you don't plug this in, I guess you can put it wherever you want on the table. It's only when it's plugged in. But it's also good for sound. You're right. As we are a bit more distance, sometimes I find it hard to hear. So it's also good to plug it in and put it in your ear because it's hard to hear others, especially if there's other members or speaking at the same time over each other. So thank you very much. I have a list. To be quite honest, though, is the list about this or about clause by clause? You're on this.
I'm on clause by clause.
Okay, thank you. Thank you. And what about you, Mr. Giovanni? Thank you so much. What about you, Madame Gladue?
Yes, I'm for the clause by clause.
Okay, merci beaucoup. What about you, Mr. Garrison?
Thank you very much.
Please go ahead. That'll hopefully be the last point on this issue.
For sins in my past life, I am a member of the liaison committee, and the process and the debate was quite fulsome yesterday, I can assure you, and lots of these problems were raised, including the ones that you mentioned, including my pet peeve as someone who uses my left hand and left ear. This is never getting way over here on my right. I can guarantee people that. And other practical problems. So a number of those were raised, and it was acknowledged that this is an experiment in trying to reduce the threats, and that we're going to do our best to make sure that interpreters are safe. But this is a work in progress. This is not the final solution.
Thank you. All right. We will now commence. Let me give you some instructions, although I'm sure you're all very learned in how we do clause by clause. But so we are now going to continue with the clause where we ended off last time. So we're debate on clause 1 with CPC-1, which was moved by MP Moore at the meeting of Monday, April 29th. And so I will now go, is this one?
So it's just resuming debate.
All right, CPC-1 moved by Mr. Moore on April 29, and we're resuming debate. I've started a list already. I have Mr. Van Popta, Mr. Givani, Madame Gladue. Mr. Van Popta, over to you, and Mr. Moore.
Thank you, Madam Chair. So just to put this in perspective, today at Justice Committee, we were supposed to have started be starting our study on anti-Semitism, which is an issue that is front and center in Canadian society today, given noisy, disruptive, and even violent protests and encampments, celebrating the atrocities of Hamas against innocent Israelis on October 7, 2023, and denying Israel's right to defend itself against an enemy dedicated to its destruction. That's a very important study, and I thank Mr. Housefather for bringing that motion forward. So instead, today we are continuing our study on a private member's bill that would repeal the section of the criminal code that says teachers and parents can use reasonable force in limited circumstances to restrain, control, or express symbolic disapproval of bad behavior. This is not corporal punishment, as we heard from several witnesses, but that's what the topic is about. Now, we would have finished this study, I think, at our last meeting if the Liberal members hadn't dropped a bombshell on us at the last minute, saying that they would be introducing yet another bill, which will be designed, apparently, to correct the deficiencies in the bill that is in front of us right now. So they're recommending, I believe, that we approve this flawed piece of legislation and that they will fix it later. How much later, we don't know. How are they going to fix it? We don't know. I think they're just telling us, trust us. So, Madam Speaker, I in good conscience cannot support flawed legislation on a promise that maybe things will get better in the future. The Conservative members of this committee have put forward what I think are some common sense amendments to fix the flaws in the bill that is before us right now. And we are supported in that, in our proposed amendments by credible witnesses such as Daniel Zekvelt and John Sikkema of ARPA, who were here last week giving testimony. Their recommendation is basically to codify the 2004 Supreme Court of Canada decision, which upheld the constitutionality of Section 43 of the Criminal Code, and that court decision also gave further guidelines for teachers and parents, and that's what our amendment is about, to try to capture that. We also heard from Ms. Heidi Yetman, President of the Canadian Teachers Federation, and she stated that while their organization fully condemns any form of corporal punishment, they do not support the proposed legislation that is before us today in an unamended form. And she was worried about, and I quote, the risk of unintended consequences that would make classrooms more unsafe, close quote. We also heard from Dr. Lisa Kelly, law professor at Queen's University. And she looked at this issue more from a parent's perspective. She started her remarks like the other witnesses did by stating that she shares the goals of the bill, namely to, and I quote again, end the practice of physical punishment of children and to protect their best care at home and at school. Close quote. But now, having said this, she expressed her concerns, and she gave a hypothetical example of a mother striking a child twice across the shins, instructing the child to sit and to sit in the car seat and get tied into the car seat for safety. She worried about consequences of such an incident, what the consequences would be in a hypothetical situation like that if the police were to have been involved. And she said, in an acrimonious divorce or a difficult family situation, one parent could weaponize the criminal law against the other for extraneous purposes. And so that's why she was saying that Section 43 needs to remain. Now, I think it's helpful to quote just one sentence from the Supreme Court of Canada decision. This is what Chief Justice McLaughlin said about Section 43, the section that this private member's bill would repeal. She said, the reality is that without Section 43, Canada's broad assault law would criminalize force, falling far short of what we think of as corporal punishment, like placing an unwilling child in a chair for a 5-minute timeout, close quote. And that brings me to our amendment, Conservative motion number 1. It is essentially, as I said, a codification of this Supreme Court decision, something Parliament, in my opinion, should have done 20 years ago. And maybe that's what the Liberals' new bill is going to address. But I would say rather than wait for a future bill, which may or may not come, I would urge all the members of this committee to vote in favor of Conservative motion number 1. Thank you.
Thank you, Mr. Van Popten. If I may move now to Mr. Giovanni.
Thank you, Madam Chair. I appreciate the opportunity as the newest member of the Justice and Human Rights Committee to share my perspective on why I will be voting against Bill C-273 unless we adopt CPC Amendment 1. CPC Amendment 1 addresses my primary concern and one that I've heard from many people, which is that Bill C-273 does not recognize or respect parental rights. Parental rights deserve recognition just as teacher safety does in any consideration of this bill and any consideration of Section 43 of the Canadian Criminal Code. And we have heard from many parents who are concerned about their place being completely excluded, undermined, disrespected, and disregarded by the current Liberal government. And it's not hard to see why many moms and dads might feel that way. At the very top of the Liberal government, there is a Prime Minister who has said quite clearly that he does not respect or recognize parental rights. In fact, last year, in a conversation with Muslim parents, he said that parents who are concerned about their rights and parenting their children are being influenced by, quote, misinformation and disinformation by the American right wing. And these comments could have been made just as easily to Christian parents, Jewish parents, Hindu parents, or Sikh parents. There's a fundamental disrespect that the Prime Minister has for the rights of moms and dads. And it's not just the Liberal Party that has this chronic ideological problem. We have a member of our committee here from the NDP, Mr. Randall Garrison, who also said less than a year ago, there's no such thing as parental rights in Canada. This is not just morally incorrect. It is also factually incorrect. The most relevant Supreme Court of Canada decision on Section 43 of the Criminal Code from the Supreme Court of Canada says quite clearly that the legislative purpose behind Section 43 is parental rights. It is not an American right-wing idea. It is a Canadian idea recognized by our highest court in the land and recognized as an important objective behind Section 43. Now, this is why we call the current government an NDP Liberal government. It's quite obvious. These parties work together on ideological objectives that seem completely inconsistent with what the vast majority of Canadians actually want from their government. And as a member of this committee, it is not hard for me to understand why so many moms and dads are concerned. So I think it's important that we point out that without Amendment 1 from the Conservative Party, we would actually be continuing the allowance of an ideological agenda that seems hell-bent on the marginalization of moms and dads in raising their children. And I'd also like to just share a statement from a member of the Muskowaquen First Nation, a granddaughter of a residential school survivor, who responded to these concerns about parental rights when Liberal Labour Minister Seamus O'Regan was going on one of his famous tangents against Canadian parents. Ms. Mbarki said, and I quote, "I am always very skeptical when the federal government gets involved in saying how parents should parent. Have we forgotten about residential schools, the 60 Scoop, off-reserve child and family services? The system saw us as savages who couldn't or can't parent." And this ugly side of our history is precisely why so many people are bothered, why so many people are concerned when the federal government and politicians in Ottawa treat moms and dads like they know better. And when moms and dads are marginalized from important conversations about child protection and raising children, it is completely unacceptable. And for that reason, I cannot support Bill C-273 unless CPC Amendment 1 is adopted. And I highly encourage all members of this committee to reconsider how they are treating parents in our country right now, and to consider CPC Amendment 1 as the way that we may restore the place of moms and dads in this important conversation. Thank you.
Madame Gladue.
Thank you, Madam Chair. So I've had a chance to reflect on all the information that was brought forward in the meetings, but especially in the Monday meeting. And so let me share with you the conclusions I've come to. The first one is I went back and I read the Truth and Reconciliation report with the recommendation 6. And, you know, in there, it was clear that the concerns expressed were to make sure that children didn't experience violence, that they didn't experience the abuse, and certainly they were opposed to corporal punishment. I think those were the clear points. And the last residential school closed in 1996. So the 2004 Supreme Court decision narrowed to what I think is the balance that would prevent the exact things that people who experienced horrible things in residential schools were worried about. The violence is illegal already. The assault and abuse is already illegal. And we've seen from the narrow definition here that the Supreme Court has put in, that's in our CPC amendment, that you're not allowed to use, instruments, belts, rulers, that kind of thing, to hit a child, and all of these protections that I think people were looking for. The second thing I would say was, when it was announced that the Minister of Justice sees that there is a problem if we remove Section 43 and don't put back protections for parents and teachers. He sees that's an issue, and he has promised to come with legislation where they will put that protection in a different part of the criminal code. This is problematic to me because I feel that, first of all, we haven't seen that legislation. And we don't know what the timing is of that legislation. And so I think we cannot remove protections that are key without putting them back in. And so certainly there is no way we could approve this bill and know that we are removing protections for parents and teachers, protections that I would say have served us well. Since the Supreme Court came with this narrow decision, there have not been a lot of frivolous cases brought. There have not been people that hugely objected to the interpretation here. And so until such time that the government could come and bring a bill that would add that protection somewhere else and remove it in Section 43, I cannot, in good conscience, support Bill 273. I think we heard lots of testimony from teachers, and I've certainly heard from parents across the country that, they believe in the use of reasonable force in the raising of the children, in protecting children one from the other as they get into their various scuffles. And so that is kind of where I've landed after somber reflection. Thank you, Madam Chair.
Mr. Moore?
Thank you, Madam Chair. I think that my Conservative colleagues have said very well some of the really important reasons why, unless CPC 1 is passed, this would be an extremely dangerous direction to go in. If I had to sum it up, it's that, government knows best. Families, teachers, they don't know what they're doing, but this Liberal government does. And this bill, I want to be very clear about a couple things for Canadians that are interested in this legislation. This legislation, Bill C-43, only applies to teachers and parents. So when we are talking about eliminating the defense contained in Section 43, we're talking about eliminating it only for teachers and parents. I have to mention, Madam Chair, since 2015, murders are up 43% in Canada. That's the highest rate in 30 years. Gang-related homicides are up 108%. Violent gun crimes are up 101%. Sexual assaults are up 71%. Sex crimes against children are up 126%. So with that as a backdrop, the crisis that Canadians are facing with crime both in rural and urban areas affecting all of us, we're here today talking about a bill that will criminalize the actions of loving parents and caring teachers. Teachers who are trying to have a safe classroom and parents who are trying to raise their children to be upstanding Canadians and citizens. And you don't have to take my word for it. We had witness testimony from Teachers Federation, from experienced classroom teachers who said to us at this committee that without the protection of Section 43, when there is physical conflict in their classroom, such as two students beating up on another student, the advice given to teachers would be to not intervene. Now, some teachers may intervene. It will be now at their peril. Why? Because of the passage of this private member's bill that eliminates a defense that is available only to parents and teachers. Now, when it comes to parents, individuals have tried to minimize the impact of repealing Section 43. And I want to quote directly from the 2004 Supreme Court decision that specifically dealt with a challenge to the constitutionality of Section 43. In that leading Supreme Court of Canada decision, number one, the constitutionality of Section 43 was upheld. So this bill is no doubt constitutional. This measure in the criminal code, Section 43, is no doubt constitutional, number one. Number two, it only applies to parents and teachers. And number three, the Supreme Court narrowed in, provided advice on what that defense includes. It's extremely troubling to me that when the proponent of this bill, the sponsor of the bill, was here at committee, all of the examples that he used as to why this bill was necessary are not covered by Section 43. They are outside the protections of Section 43. He used the example of a student being punched in the face. The Supreme Court specifically said hitting someone in the face is not protected by Section 43. He used the example of someone being struck with an object multiple times. Again, the Supreme Court specifically said that hitting someone with an object is not protected by Section 43. The example was used of pushing someone down the stairs. Again, these ridiculous examples of clear abuse that all of us are against. I don't think there's anyone around this table that thinks someone should be able to push someone down the stairs. The Supreme Court of Canada doesn't believe someone should be able to push someone down the stairs. This is the basis on which this private members bill was brought forward. It's completely based on misinformation, but the consequences are real. And I want to read directly from Chief Justice Beverly McLaughlin, writing for the majority in this 2004 Supreme Court of Canada decision, where they warned Parliament 20 years ago that if they remove Section 43, parents would be criminalized and families will be ripped apart. So in that decision, I'm quoting directly, "This risks ruining lives and breaking up families, a burden that in large part would be borne by children and outweigh any benefit derived from applying the criminal process." So the ruling of the Supreme Court is that if Section 43 does not exist, it will lead to families being broken up. That's a pretty strong statement by the court. It is why CPC 1, our amendment, would fully implement all of and codify the ruling of the Supreme Court and the definitions that they've applied to Section 43, the parameters they've put around Section 43, and the very constitutional findings that were made in that decision. So, Madam Chair, myself and my colleagues, we stand against Bill C-273. It strips away the rights of teachers and of parents. It interferes in families and in classrooms. It's major government overreach. And it has, in the words of the Supreme Court of Canada's leading decision, it risks breaking up families. And I would conclude my remarks there, except to say that what happened on Monday was extremely extraordinary. I mean, I've been a member of Parliament for quite some time. I can't recall a time before where we're dealing with a private member's bill, which if passed would have the same effect in law as any piece of government legislation. And we find out at the last minute as we're dealing with this bill, don't worry, we recognize there's a consequence to passing this bill and there's going to be government legislation. Well, number one, that may or may not happen. Number two, what does the government legislation look like? We have no idea. Does it apply only to parents? Does it apply only to teachers? Is it expansive enough to protect teachers and parents from the impact and the fallout of the passage of C-273? This is not a proper way for us to conduct ourselves as parliamentarians. I think we have to look at the legislation before us. We have to look at it and its impact in its entirety if we were to pass it. So if we were to pass this bill, and I urge members around this table for the protection of parents and teachers that we pass CPC 1, but if we were to pass this bill without the Conservative amendment, it will put teachers and parents, and by extension, it will put children at risk. So I'm speaking in favor of CPC 1 and speaking strongly against Bill C-273 unless it is amended. Thank you, Madam Chair.
Mr. Garrison.
Thank you very much, Madam Chair. I don't want to prolong the debate on this. I have heard from numerous stakeholders, I guess I'll call them, who are interested in this bill since Monday. And there are, I think, safe to say somewhere around 90 letters have been directed to the committee. And there's three themes in most of those letters. One of those is, of course, that this is recommendation number 6 of the Truth and Reconciliation Commission. And most organizations around this table and at the national level are committed to advancing truth and reconciliation. And we are in danger in this debate of substituting our opinions about the effect of Section 43 for those clearly stated opinions and understanding of the section which come from Indigenous people. So I think that's a danger here, and that not passing this bill does not advance reconciliation. The second thing is the Conservative amendment, which we're speaking to now, actually says that use of force can be used to educate and correct children. And we know that all the research on child psychology shows that this is not an effective way of dealing with kids. And that, in fact, what use of force with children does is to teach them that when the frustration occurs, the proper response is violent or force. And when Mr. Moore talks about the great trends in society, I would argue that this section actually contributes to the increasing violence we see rather than solving it. And the third thing that they clearly say in most of these letters is that children have rights, and that in Canadian law, especially Canadian family law, parents have a responsibility to support and affirm their kids. And use of force against children is not a way of supporting and affirming kids. And it remains peculiar to me that this is the only debate we have in our society about use of force, is whether we can use force against kids. We're not debating this about use of force against anybody else to correct or educate them. It's only children. And so that seems peculiar to me, and frankly, it seems offensive. And so while I understand some of the concerns that conservatives have raised, I believe it's incorrect to say that teachers opposed repeal. I think they said very clearly they supported repeal. They had concerns, and the government has agreed to address those concerns. That's how we got to where we are today. And so I'm hopeful, in the spirit of advancing reconciliation, that we can finish our work on this bill today, and that we can pass this bill and move on to other important things which other members have mentioned that this committee needs to deal with. But there is a broad national call for action to implement Truth and Reconciliation Commission Call to Action number 6.
Monsieur Fortin, parole est à vous. Merci.
The floor is yours, Mr. Fortin. Thank you, Madam Chair. I have some questions for our witnesses today, if that's all right. Firstly, I'd like to know if they could clearly explain some things to us. The goal of Bill C-273 in repealing Section 43 is really the only reason that the bill is in front of us, to repeal Section 43 and to respond to recommendation number 6 from the Truth and Reconciliation Commission report. So in your opinion, could you tell us what the TRC report is really aiming to accomplish or targeting here? Yes, thank you, Mr. Fortin. So the report is focusing on physical and sexual abuse in institutions, so we're not necessarily talking about residential schools. The 2015 report is targeting any type of physical and sexual abuse. So recommendation number 6, if I go off of what you're saying, targets which physical and sexual abuse? Who, where, when? Could you specify, please? So the report establishes or targets all physical and sexual abuse that Indigenous people have faced in the past, so the scope is quite wide. So recommendation number 6 is talking about physical and sexual abuse. Sorry, Mr. Fortin, if I could just add something here. Essentially, it's looking at the use of violence, so corporal punishment, in residential schools. But also, more broadly, how can I put this? Section 43 would normalize the use of physical violence, corporal punishment. And so in my understanding, recommendation 6 is focusing on this corporal punishment. Okay. So I've understood that we're referring to physical and sexual abuse. You said we're referring to what happened in the past. broadly. So I'm assuming we're talking about the beginning of Canada as a country up until today. And the report is from what year? 2015. So from 1967 to from 1867 to 2015, we're talking about all the sexual and physical violence that Indigenous children have faced in schools. Is that the case? That's correct. Yes. So physical and sexual violence inflicted upon Indigenous children by any teachers or personnel in these schools. And is this in alignment with the calls for action from the TRC? Well, call to action number 6 calls for the repeal of Section 43 because currently they consider that corporal punishment is still allowed in Canadian institutions based off of a court decision. So you may not have the answer, and I would understand if that's the case, but if you have read the reports, I was wondering, were they referring to physical and sexual abuse on a broader scale for all children across Canada, or are they specifically referring to, and I'm not trying to undermine this unacceptable situation, but are we speaking only of sexual and physical violence against Indigenous children in residential schools or all children throughout Canada? So the TRC report focuses only on children in residential schools, so Indigenous children. It's not more broad than that. Okay, thank you. Another question. So I know you've heard the debate that we've had recently on this issue. And I know that our colleague that represents the Liberal Party said that the minister will soon table a new bill to make up for the shortcomings of C-273. This would allow for a certain use of physical force for those who have parental authority over a child for the upbringing of this child. But for the time being, if we repeal Section 43, could parents and teachers find themselves in a difficult situation where they don't necessarily know what could happen to them? And if you allow me, I'd like to specify something with you, clarify something rather. So when we talk about parental authority, a parent, a teacher who witnesses a fight between children, for example, and wants to intervene to separate the fight, and they want to use physical force, of course, to break it up. In your opinion, could this person be taken to court for that? So looking at the way we establish assault, it's quite broad. So yes, this type of situation could lead to criminal charges for assault. That depends on the case, the facts that we're looking at, what happened to the child. So the Crown would have their own discretion in this case in terms of their decision on the charges. There are more disciplinary processes as well. It's not always criminal. But yes, in this case, a teacher could face charges in this case. Now, in Section 43, we can't necessarily say if the teacher who is accused of assault will necessarily be found guilty. As I said on Monday, there are forms of defense under common law that could be used. De minimis, for example, and necessity, which were used in the Canadian Foundation ruling from the Supreme Court. But then there's also deemed consent. The problem here is that I'm unable to respond to your question with certainty. What would happen in every case to a teacher in the example that you shared, whether or not they would be found guilty for having used this physical force. When we look at Section 43, it would apply, but the judge at the end of the day in the Canadian Foundation ruling took into account these common law means of defense that I just mentioned. If, for example, we have a child who is causing problems in a classroom and the teacher would like to ask the child to leave the classroom, the child doesn't go out, and maybe he wants to grab them by the arm to escort them out of the classroom. In your opinion, could this teacher be charged? It's essentially the same answer that I gave to your previous question, Mr. Fortin. It depends on the specific facts of the case, so I can't be sure, but it's essentially the same situation that applies. Currently, there are certain terms that we're not using in Section 43 around parental authority that are used in Quebec. But I do understand what you're saying, that there are certain aspects of parental authority that are given to the teacher that needs to protect the child. So without Section 43, in certain cases, again, it depends on the specific facts pertaining to that case, there are certain means of defense in common law that could be used to defend the teacher in this case, if they could not use Section 43. So there are means for them to defend themselves outside of Section 43, but currently Section 43 offers this defense. Is that correct? I'll answer, and then I think my colleague could add to this, because I can see that she has something to say, but basically the answer is yes, you are right. Section 43 offers protection for teachers and for parents who use reasonable physical force in certain circumstances towards a child that is under their care. In some cases, this is similar to means of defense that exist in common law. Yes, if I could just add, what we see in rulings throughout the country in terms of the application of Section 43 is that this section is the foundation, and then if it doesn't work, then we move on to the minimus defense, legitimate defense, when we're protecting a child who is in a fight with another child, for example. That's what Section 43 does. So the child is the focus here, but if we can't use Section 43, then we do have provincial laws, we have regulations from school boards, school associations, so there are other options here as well.
Mais si je vous comprends bien.
So if I understood correctly, what both of you are saying is that Section 43 covers all these situations, and so if we get rid of it, we're going to simply have to compensate with other rules coming from our legal system. But the situations that are protected under Section 43 could also be protected by other sections or other means of defense in common law. Yes. Now, we can't give you an absolute answer to your question, because Judge Arbour in the Canadian Foundation case stated that other means of defense could apply, but as my colleague explained, because we have Section 43, we are going to refer to that firstly before we move on to other means of protection. So again, after Section 43, if it cannot be used, we have other means of defense, such as de minimis. We have implicit consent that could apply as well. But we would need to see an evolution of case law. So, of course, I have many different situations I could bring up. I don't want to waste our time, but imagine we have a child who is causing problems and we want to use some physical force to maybe make them sit down. Essentially, the person exercising parental authority in this case has several means of defense. Yes, so the court will take into account the facts that they have on the case. For example, if someone, some witnesses may say that, oh, they simply gently touched the child on the shoulder. Others may say that they used more force than that. They're going to listen to witness testimony, but then there are other means of defense that would allow for a more fair ruling on the force that was used against the child. So if I've understood correctly, a teacher or a parent that intervenes in a fight or that removes a child from a room with anger, with excessive force disproportionate to what is needed, would not be protected by Section 43. That is correct. That's what we have found in the Canada Foundation ruling. The excessive use of force is not protected under Section 43. Now, do you have any examples of situations you could show me? Different examples of case law where an individual has used disproportionate amount of force against a child to, for example, break up a fight between two children and used anger and excessive force to remove a child from a classroom? And has this been recognized by a court as being protected under Section 43 in the case where there was an excess of physical force? Was it protected by Section 43? Do we have any case law for this? So you're asking of a case where Section 43 was applied for excessive force? No. There are cases where the defense was stating that the force was not excessive. I have a case from December 2023 in Ontario where the witness said that the child was grabbed in an aggressive manner, that the person using the force seemed to be quite angry, and the accused and other witnesses said that this was done in an appropriate manner, respecting the rules. So in this case, we could see that there was a clear excess of frustration, and I've been able to consult numerous cases, not all of them, but in all of these cases that I've consulted, Section 43 did not apply. Thank you. Now, at the beginning, you said that C-273 is focused upon the Truth and Reconciliation Commission report, and more specifically, recommendation number 6. And you said that this is targeting cases that were found in residential schools. And the fear was that Section 43 would, to take my colleague's expression, normalize violence against Indigenous children. Do we have examples? Now, of course, we all know that this happened, but do we have any examples in our case law that set the standard that this was acceptable, under which Section 43 allowed someone exercising parental authority in a school to act in a violent manner, be it sexual abuse, physical abuse against a child. Do you have examples in which this was deemed acceptable under Section 43? To my knowledge, no. Mr. Viltort, I imagine you have the same answer. So specifically for residential schools, we may find some examples, but we can refer to the Judge Arbour ruling for Canadian Foundation that looked into how Section 43 was applied in the past in different situations that were, or rather, that would be considered as an excessive use of force today. And in those cases, Section 43 could not apply. We've, of course, heard of some more extreme situations. The decision today is clearly that Section 43 does not apply to extreme uses of force. And in this case, the person could be accused of assault. So if I've understood correctly, what C-273 suggests is that we repeal Section 43 because the fear is that it may authorize forms of violence that it has in fact never authorized and would not authorize now. And we're focusing here on some very rare, extreme, dramatic cases of violence against children. And so C-273 wants to repeal Section 43 for, and I'm sorry to say it, but for nothing. Because the type of violence that we're looking at would never be allowed under Section 43. And we're putting those who exercise parental authority in a situation where they're simply going to have to find a replacement form of protection for Section 43, maybe in other articles of the Criminal Code or under case law, the things that could make up for these shortcomings that are left by repealing Section 43. That's really what we're doing here, right? Well, you're referring to a very broad range of cases. Here we're focusing on the most serious cases of the use of violence and excessive frustration, whereas in Section 43, it's still applied for cases where, as the Supreme Court stated, for more transitory forms of violence. And this applies to those who are exercising parental authority or parents themselves who are not using excessive anger or frustration, who are not touching the child's head, and who are using a certain controlled form of physical force. We are considering the examples that it covers are less serious than what you're referring to. So you may not be able to give me a political opinion on this, but how far can you go in explaining to me what would be the advantage of repealing Section 43? In your opinion, does Section 43 create a problem? Maybe back in 1920 it was a problem, but today in 2024, is Section 43 problematic? Now, of course, I cannot give you any legal advice this morning, but so, of course, there's the Truth and Reconciliation Commission. We also have other organizations that have given us a lot of recommendations from 1995, 2020, in 2022, different recommendations to repeal Section 43. And this supports other texts that state that corporal punishment is harmful to the development on an emotional level for the child, there are other elements to this that are related to what I've just mentioned that state that we should repeal Section 43. So I just want to make sure that we're understanding each other. When you've spoken of other states, of the United Nations, and their stance on corporal punishment. What we're aiming to abolish here is actually corporal punishment. So, for example, I'm going to hit you because you weren't nice. Corporal punishment. But the use of reasonable force in the upbringing of a child is not really what we're talking about here, I think. Of course, this is at the heart of our discussion on Section 43. I think, of course, corporal punishment 100 years ago might have been acceptable, but of course it's not today. We agree on this, but it's a different discussion when it comes to reasonable force. So we really need to distinguish between these two things. Let's set aside corporal punishment. The use of reasonable physical force, was it recommended by the UN that this be abolished? I don't think so, but could you speak to this? So the UN has looked at Section 43, and it was interpreted by the Supreme Court as well as the United Nations. But Section 43 does refer to corporal punishment. But then we have the use of force for other motives, the use of force to punish the behavior of a child, use of force to protect against pain or discomfort. So the UN states that we need to remove corporal punishment, correct? Yes, that's correct. And so the Bloc Québécois amendment that was tabled and was not adopted does respect the requirements of the UN, to take some trendy words, uses common sense, because of course we want to abolish corporal punishment, everyone agrees. But Mr. Viltor, could you speak to this too? No, I agree with my colleague on this. I don't think I have anything to add. Now, a question for both of you. We're in a situation where, likely, given the numbers that we have, the number of Liberal and NDP members who have decided to support C-273 based upon the idea that the minister will later table an additional bill. Do you think that the minister could save us later from this? What provisions would this require to protect parents when they use reasonable force in the upbringing of their children? In your opinion, where could we implement this new legislation, and how could this be done? Mr. Fortin, I can't speak to this. The questions of how and when, the restrictions on this, these are questions that you should ask the minister. Now, generally speaking, if it's not under Section 43 of the Criminal Code, where we have these forms of protection, I would assume that you'd have to take a look at the general application of clauses related to assault, but I cannot speak further to that. Okay, so I guess it's useless to ask you if you are optimistic about this. I cannot answer that question. Okay. I have no further questions, Madam Chair. Thank you. Thank you, Mr. Fortin.
Yeah, just quickly, Madam Chair, very interesting questions from Mr. Fortin, and one thing I wouldn't want people to be left with any illusion on